Okay, I'm going to go ahead and call to order tonight's meeting of the City of Santa Rosa Planning Commission and ask for roll call, please.
Let the record reflect that all commissioners are present except Commissioners Crocker and Dipple.
Okay, thank you. Next, we'll move on to the approval of the minutes of our December 8th meeting. Any comments, corrections on that? Okay, not seeing any. Those will stand as printed. Next, we're going to move on to public appearances, which is a time for any member of the public to come down and address the commission on matters of interest to the commission that are not listed tonight as a public hearing. So I'm going to go ahead and open public appearances, and if anyone would like to come down and speak, I am not seeing anyone rise, so I'll go ahead and close public appearances and move on to Planning Commissioners' report. Any reports from commissioners today? Okay. Well, I have one. We have in front of us some written information for the Planning Commission. We're being given an opportunity to form sort of an ad hoc committee. As you know, last year we did the interim zoning code measures regarding cannabis cultivation, and the city council has had a committee ongoing working on kind of a more broad outreach and a more formalized plan for our zoning code. That's getting close to coming to an end where they're going to be going out and having public forums presenting what's come out of that committee. So we're being given the opportunity for those of us that are interested. I think, we had 3 volunteer commissioners that are interested to attend whatever city council subcommittee meetings are left, attend public forums, sort of like we did with the Roseland specific plan public meetings. We'd be going as an observer to be able to watch the process, to come back and report to our fellow commissioners the process, so that as it's moving through the process, we can see for ourselves kind of what the flavor is and the temperature of the public, how things are changing before it comes to us in, sort of the staff presentation form, so that we have an opportunity to kind of follow it before it just becomes a formalized document in front of us with one public hearing. So staff gave us the dates of things that would be coming up, and so I'm wondering if there are commissioners that would be interested in participating. I think if we have 3 of us, then if one or more of us can't go to one particular meeting, it would still be covered. So, okay, so you're interested, Casey? Okay, I'm also interested. I know I won't be able to do maybe some of the late March meetings, but turn it up, I'm sorry. Oh, okay. We'll talk into it louder. Okay. Okay, so let's go ahead and say that Commissioners Edmondson, Groninger, and myself will be a part of that committee. Staff is also going to give us the opportunity to meet. The 3 of us would meet with staff, and they would give us an update as to what has happened over the year with those meetings, and give us a lot of information before we go out and do the observations. So, great. Anything else we need to do on that? Okay. All right. So let's move on to department reports.
Okay, is this on? Hello. Okay, a couple things to report. Well, we will have a meeting in a couple of weeks. We have a few items, more tentative map extensions. We're starting to get a lot more tentative map extensions as the automatic state extensions are ceasing their value, and now our tentative maps in the city are eligible for 1-year time extensions. And so you'll see a string of those, and we have more to come. I didn't get it out to you today, so I'm going to do that following this meeting. But staff has put together a summary, a year-end summary on our housing production in terms of processing permits through planning and engineering, which is a critical step before housing moves into the next phase, which is building permit phase, and then into construction. And so we've put together a summary of current figures, and you can see that there's a lot on the horizon, but kind of where that is and how important that is for it to continue to move on. So we still have a lot of work to do to get housing from what I consider paper approvals to sticks in the ground and getting housing constructed. And as you know, it's #1 priority for the city, and it's all hands on deck for that. So I'll present that report as soon as I get that available to you. Upcoming meetings for the City Council. I know it's of interest to you to stay in touch with the council actions. Looking forward on future agendas. Well, as you know, the council is newly seated and they're starting to make their appointments to various city committees and boards and commissions. And so we haven't had official appointments yet for our seats on the Planning Commission that are available, but that's going to be forthcoming. So as soon as I know, I'll let you know. There's a number of appointments, and so there's a lot of work to do still in that regard, and that typically happens in January and sometimes into February, so we'll remain patient. Other items that the council will be working on in January, there's an item on January 31st. It's a report item on a quiet zone for the SMART train, and I think that's just of interest to the Planning Commission because SMART has such a catalyst for our land use decisions. And what will be of interest is just what is a quiet zone and how does that function and how does that relate. And so you might want to pay attention to that item. Also on the 31st is an appeal that's being heard regarding the Deturk Winery Village project. That's a 185-unit housing project in our downtown station area, right across the street from the Deturk Round Barn. And it's on appeal. It had received an action from the Cultural Heritage Board and Design Review Board, and the applicant has appealed that action to the City Council. That project will have entitlements, should it move forward, that the Commission will have the responsibility to review and take action on, but just wanted you to know that before it even gets to the Planning Commission, it's pursuing its design review and landmark alteration entitlements, and that's going to be a point of consideration on January 31st. And then another one is just to give you a heads up that the council, as they get seated and settled, we go into a goal-setting session. So we're still working on the goals from a couple of years ago. In fact, we're heavy in the throes of them, and those priorities that came out of that last session was Roseland annexation. We did the specific plan, but we're neck deep in moving forward with annexation. There's a lot of work still to do with community outreach and engagement and the actual annexation process of Roseland, but that was one. Obviously, infrastructure, housing policies. We adopted the housing action plan, but there's a lot of initiatives still to do. So we're prioritize the second dwelling unit ordinance and inclusionary housing. So we're kind of in the throes of starting those work plans and addressing homelessness. So again, a lot of work still involved in not just our interim policies about that, but codifying some permanent policies about shelters. So anyway, we still have a lot of work to do. A lot of the same priorities are still there. But March 10th, the City Council will have a chance to revisit those and see if there's refinements or new priorities, new goals. So that is that for that. And then while I have your attention, one of the things that is in our work plan for the Planning Commission is education and training. And we've talked about different opportunities for that and trying to be creative. One of the opportunities is to attend conferences that are specific to commissioners or offer a menu of land use related topics. And so As I mentioned before, and last year we took advantage of this one, was the League of California Cities puts on an annual Planning Commissioners Academy, they call it. And this year it is, what did I do with that? This year, it's March 1st to the 3rd. It's in Los Angeles. So I'm going to pass those. What's just come out is sort of the quick glance conference, so you have an idea of what would be covered at that. It's a short session, but it's focused on. It's really focused on new commissioners, but sometimes it's nice to go back to the basics. So I just want to give that as an opportunity, and it's a great networking, learning opportunity to be with other planning commissioners from the state of California. And I'll pass that out. Another opportunity that we recently talked about was joining the planning team and going to the APA California conference. This year, it will be in September 23rd to 26th, and in Sacramento. And the bonus of that is probably more of us could go in terms of the expense of going to a conference. We could go together. And the benefit of the APA conference, they have special sessions targeted for commissioners. And the commissioners I talked with this last conference really enjoyed their experience, so that's why I'm bringing it to you as an opportunity. They have a broad menu of topics, and so the benefit of that, especially if we can get as many commissioners to go, is we can all bring that back, and that's a great way. We can even do a session about what we learned in that conference. So I'll pass that around, the date, and then you can take a look at what last year's conference looked like in terms of the scope. So just keep that into consideration, and then at some point, probably at our next meeting, we'll start figuring out which of these opportunities we want to take advantage of. Either all go to one or split up as interest, as we're interested in doing. Any questions about that? Okay.
Oh, Claire, I have just kind of one question about a potential upcoming meeting. Do we have any ideas when the Southeast Greenway will be coming back for a joint meeting? Just so we can be aware that if there is a date potential.
Yeah, we don't have a specific date. That item will likely be scheduled after the goal-setting session of the City Council. So again, that's March 10th, so it'll be sometime after that.
Okay.
The resources that we have to put these items together are competing with each other, and right now, the housing initiatives are taking priority. So we've had to postpone that item for just a little bit, but we'll get back to it as soon as we can.
And we'll have plenty of notice so that we can.
And you'll have plenty
mark
of
our calendars
notice.
Since it's
yes.
a different time than we typically meet.
That's my job. I'll do it.
Okay. Okay, thanks. Okay. Statements of abstention by commission members. Abstentions tonight. Yeah, Commissioner Edmondson.
I will be abstaining from item number 10, the Meadowood Ranch subdivision. The project applicants are clients of the law firm that I work for.
Okay, thank you. Okay, so with that, we'll go ahead and move to item number 8, which is our first public hearing tonight, which is the Fox Hollow and Somerset Place amendments to tentative map conditions. It is an ex parte disclosure.
I revisited both sites
Okay,
and learned nothing new.
okay. Any other ex parte disclosures on anything? I had a brief conversation with Ms. Wagner about the issue. Nothing else to report, learned nothing new. And so with that, Patrick Streeter is staff, and you're going to be doing your preview.
Yes.
Great. I love that. I'm just not used to it. It's like, why is Ms. Hartman
We'll find
here
a
instead
rhythm.
of Patty?
We'll
Okay,
find
go
a
for it.
rhythm. So one of the things, one of the things that we're doing differently this year is because of our emphasis on housing and housing construction and how these individual projects fit into the context of that overarching goal. One of the things that we're adding to all of our presentations across boards, commissions, and council is the slide that you see here. And this first item covers two different projects. We are looking at amending a condition of approval that addresses housing to actually give more flexibility in terms of reviewing alternative proposals that meet city goals in terms of implementing particularly inclusionary housing. So what you see here is graphically you see that we are looking to have 5,000 new housing units in various income categories. It's housing for all. We need housing in all categories. And so you see we have 51% of the housing that we need is in the market rate category, and then we have moderate needs, low and very low. And oftentimes the way the city gets very low is through in lieu housing fees, coupling that with federal and state grants and working with affordable housing developers. But we are striving every day to figure out how we can get inclusionary housing units in those categories as well. So we get them with development as opposed to through the in lieu fees. So what you see here is the representation of these two projects that you are looking at tonight, Fox Hollow and Somerset Place. Both of them came to the city and were entitled with 100% market rate units. But as a housing development, they were required to pay an in lieu housing fee. So that fee would go to that blue category, very low, at some time in the future, working, partnering with the city and all of that. What's before you tonight is a request to make a change, and Patrick will go through that. It's to allow for consideration of a more creative idea for inclusionary housing that will work with making inclusionary housing possible in Somerset Place. So there's a little asterisk there under moderate because there's an opportunity to add inclusionary moderate units to Somerset Place. So anyway, I'll let Patrick get into the specifics of that, but that's what this is representing, is that typically they've been coming in as market rate, especially a lot of these items that you'll see as tentative map extensions. So this day forward, we'd like to have more flexibility in trying to get inclusionary at this point. And the way we wrote conditions is very tight, so we'd like to bring some flexibility into that condition language.
Okay, now Mr. Streeter will give the staff report.
Thank you, Chair Sisko, members of the Planning Commission. Patrick Streeter with Planning and Economic Development staff. So the item before you is it's a request coming from staff to modify the conditions of approval for the Fox Hollow and Somerset Place tentative map resolutions. And as Ms. Hartman commented on, it would provide more flexibility in meeting this housing action plan goals. And so just a brief background on why this request is before you. The city code has the housing allocation plan, which details the steps that the city wants to take in order to address that request for housing for all. Typically, market rate residential projects will meet their housing allocation plan requirements through two standard routes. One would be an affordability contract, which would establish certain properties in a residential development to be marked for that very low income category, and that would be an agreement that would last for 55 years. The other option is through payment of those in lieu fees, which is then pooled by the city and applies towards inclusionary developments down the road. The housing allocation plan does include a section which discusses innovation, and it says that innovation is encouraged. So there are other options aside from these two typical routes for residential development, which brings staff's request that the commissioner provide the city staff through the Planning and Economic Development Director with the authority to consider those other types of approaches for meeting compliance with the housing allocation plan. The catalyst for this request is coming from two subdivisions that are approved. They are the Fox Hollow subdivision in northwest Santa Rosa and the Somerset subdivision, which is in southwest Santa Rosa. The Somerset subdivision received its tentative map approval from the Planning Commission in 2008. Fox Hollow received the approval in 2015, and Fox Hollow has already begun construction on that site, so their rough grading permit has been approved, and they've already started grading the site for development. The request coming from staff meets several of the general plan goals, which the housing allocation plan is constructed around addressing these housing for all goals in the general plan, which has diversity in housing stock, finding ways to fund additional types of housing beyond market rate. And specifically with the housing allocation plan, there is currently no requirement for projects to provide on-site affordable units. So the easiest strategy for most developments is to pay those housing in lieu fees once they get approval for their development. With for sale housing, those impact fees are paid at the close of escrow. So they're not paid up front. The houses are built. Then once they're sold, that fee is collected by the city. And those fees are ultimately consolidated into an affordable housing development, but it could be several months or years after those residential units were constructed. Staff sees an opportunity in this innovation encouraged clause, which would address the current housing crisis, and that it gives a little more flexibility for other types of approaches beyond the payment of in lieu fees or projects that are upfront presented with on-site affordable, with an affordable element. Regarding the California Environmental Quality Act, Somerset Place and Fox Hollow both received mitigated negative declarations to cover their CEQA requirements. At that time, both of them had a standard condition of approval requiring that they comply with the housing allocation plan. So the scope of those environmental reviews doesn't change with the modification that's requested tonight. And the current conditions in the approvals for Fox Hollow and Somerset Place, as Ms. Hartman commented on, are restrictive. They allow either the development of on-site affordable units or the payment of the in lieu fees. And so staff is requesting that these conditions be modified to allow, so it's a lot of legalese in this requested condition, but essentially it allows for the first two options, which are the provision of on-site affordable units, payment of the fees, or some other strategy that meets the goals of the housing allocation plan as determined by city staff. And the reason that this request is coming up as a modification to those conditions as opposed to just a proposal for meeting the housing allocation plan before the commission tonight is that this has come about after several months of conversation, in this case with the Fox Hollow and Somerset Place developer, City Ventures, between planning staff, economic development staff, housing and community services staff, trying to work out a way of meeting compliance with the housing allocation plan and in a creative fashion. The current proposal that was included in the packet that was sent out to the Planning Commission includes the development of 11 moderately affordable units that would satisfy in lieu of paying the in lieu fees would be the development of these units, and that would be through an executed agreement with the Housing Authority. And so that agreement would contain all of the provisions for if the custodian of those moderately affordable units is to dissolve at some point, what happens to the units then? If the developer is unable to provide the city with those units and in a timely fashion, there'd be protocols for each of those. And that would be encompassed within this agreement with the Housing Authority. And the reason that staff is asking that authority be granted to the planning director is that this is one concept that at this point is pretty far along, but it could change if the agreement falls through and we're unable to work out terms that work for city staff and work for the applicant. Then we'd want to be able to fall back on the in lieu fees or work out some other strategy that may not involve an agreement with the Housing Authority. So by granting the authority to the planning director, we'd be able to have more flexibility in addressing the requests from developers to come up with innovative strategies. The action tonight would also inform us with future residential developments as to the Planning Commission's kind of take on this approach. So right now, we have standard conditions that require compliance with the housing allocation plan. As I showed previously, they're restrictive right now. They give those two options, with the authority falling to a public hearing and coming back before the commission for an innovative strategy. So we would amend our standard conditions to allow this third option going forward. Again, it would still come before the Planning Commission at the time of the tentative map approval for the ultimate decision as to whether or not to include those conditions of approval on future developments. The project was noticed as a public hearing per our standard city procedures, and neighbors of both the Fox Hollow development and the Somerset Place development were noticed about this action, and no comments have been received. I also want to point out that in the staff report, the language given for the change of conditions differs slightly from what's in the resolution. So what's on the screen right now is what we ultimately landed on. The intent of the language is the same. It's just the way it's written is slightly different. So in the draft resolution is the language that you would ultimately be acting on tonight. And so considering these factors, it's the recommendation of Planning and Economic Development that the Planning Commission amend resolutions number 11254 and 11723, which approved the tentative maps for Somerset Place and Fox Hollow, to provide the planning director or the director of Planning and Economic Development with authority to accept innovative housing allocation plan compliance strategies. And a representative from the Housing Land Trust of Sonoma County is present, as well as a representative from City Ventures, who was the applicant for the Somerset Place and Fox Hollow tentative maps, and city staff is also available to take any questions. Thank you.
Okay, Mr. Street, I just want to clarify for the commission here that really our purpose and purview is to vote on whether or not to amend the language just to include the flexible option. So we'd have the in lieu fees, the inclusionary, and now an option for innovation to be decided on by our director. What we aren't voting on is the plan itself that has been sort of the prompter of this, right? And even though maybe the land trust here might give us some interesting details and we can ask questions about that, what we're voting on is simply inserting that new language.
That's correct. Yeah, that agreement was the catalyst for this request coming from staff, but the action on the Planning Commission's part tonight is to grant the authority to consider those other strategies. So it was included in the packets for reference, but it's not directly related to the action tonight.
Okay, just want to make sure we know that we're not going to be picking all of that apart or voting on that we're really just looking at the language. And then just for my clarification, the language that's in the draft resolution is what we're going to be doing, or are we going to be referring to what you put on the screen?
The draft resolution and what are on the screen are correct. The staff report, the written staff report has incorrect
Okay, so I don't need to worry about anybody making an amendment when we get to that point.
Correct.
Okay, good. Just want to make sure I understood that. Any other, Commissioner Gronica.
Just so I'm understanding again, you mentioned that at some point, in your presentation, that we would be seeing proposed amendments coming back to us for the housing allocation plan. So the action, I'll finish, I guess. The action we take tonight does not amend the housing action plan per se, right?
No, this action doesn't change anything in the housing allocation plan. And for this project, future techniques of satisfying that housing allocation plan will not come back to the Planning Commission. The authority would rest with staff. My comment was that this action tonight would inform us for future residential developments, that we would include this condition as a new standard condition of approval, as opposed to the previous standard condition of approval, which gave the two options of on-site affordable or payment of fees. This provides that third option, and that would be attached to draft resolutions that come back before the Planning Commission for future residential developments. So it would be at the discretion of the Planning Commission at that time whether to keep that condition on or revise it as you see fit.
Okay, any other questions of staff? Vice Chair Stanley.
So as I'm understanding it, and Chair Cisco made it more clear to me now, that we're not actually voting on the land trust deal that City Ventures is working on. So I guess in order for me to understand better what that means, I love the idea of having innovation in any condition of approval for a project, but maybe staff, somebody can explain what the basis of that analysis would be. It's easy for me to look at an in-lieu fee and see what the basis of that is. It's easy for me to look at building them out, the units out. You certainly see the direct relationship between the housing allocation plan and what our responsibility is. And this land trust deal is very innovative, but we don't know what other ones could be. So it would be helpful to know from staff what the basis of their analysis would be to determine whether something is actually innovative. Mm-hmm. And I don't know whether you've thought that deeply about it, but it would be good to hear that, because we are turning over an authority to a regulatory authority back over to staff, which is always a good thing, I think, but it'd be helpful for me to understand what that analysis meant.
So I can briefly touch on it, that the current proposal is the result of several that have come forward over. The initial suggestion was a dedication of property to the city to satisfy those housing allocation fees. And staff wasn't totally on board with that, and then it went to the Director of Planning and Economic Development. We also talked about it with the Director of Housing and Community Services, and the City Attorney's Office has weighed in throughout this process as well. And so the project evolved from that dedication of property into this this custodianship that would be granted to the Housing Land Trust, and it's involved several meetings between the applicants, the written proposal that was presented, which was then vetted through the Director of Planning, through Housing and Community Services, City Attorney's Office. And the real reason that we're asking for this authority to be switched over to staff is that there's a level of uncertainty that raises when all of these negotiations are worked out and we settle on a solution that satisfies all of our requests and also addresses that housing allocation plan, but then it's still subject to a public hearing before a Board or Commission, and if something changes from that, resulting in several more months of discussion. So the real purpose behind this request is to streamline that process, but it is vetted through several different sections of staff. It's not just the director that would look at something and vote to approve it. It's a proposal that is given a substantial amount of consideration.
But is that, excuse me. So I understand that, and I support that. I guess I'm trying to find, is there a technical threshold that you're looking for in order for the planning director to sort of approve an innovative process? Is it technical, or is it more philosophical, that we're trying to find ways to get affordable housing into the marketplace? And so those innovative strategies are based on, sort of a group of very intelligent people in our staff that are looking at that and trying to come up to make sure that we are in alignment. I'm not against this at all. I guess I'm just trying to get my head around what authority we're handing over to the director, and what the basis of that decision-making process is. Because I think the land trust deal is a great idea. That's a perfectly good example of an innovative process, but I've seen other quote-unquote innovative processes in communities that don't deliver the housing to the market, and that's, at the end of the day, that's what we're trying to do.
Yeah, I think it's inherent in being innovative that we don't have technical standards to work with.
Right.
I don't know if Ms. Hartman would like to add a little bit more to address your comment.
Well, I think his last statement is spot on. It's going to be some technical and some qualitative, and the section that really addresses alternative compliance in the housing allocation plan, section 21-02070. It's referenced up here in this condition. It's always been there in our housing allocation plan. You can do. There's a list of different things that you can do. You can pay your in-lieu fees. You can do inclusionary housing. If you do inclusionary on-site housing, yes, technically, there's a threshold, so there is a combination of technical and then also intent. The intent is affordable housing at certain levels and by contract, not just by design. And so when we wrote the housing allocation plan, when staff wrote it, prepared it, vetted it, and it was adopted, we tried to think of all different kinds of ways and be creative proactively about all these different ways to achieve the objectives of affordable housing. But there's always that need for an other or otherwise provided category. And really what's at issue here is we weren't seeing a lot of innovation in the last 10 years. People were paying the in lieu fees, and 100% affordable housing projects were providing the affordable housing on site, and there wasn't a lot of in between. What we're seeing right now is a lot of innovation and a lot of interest in innovation to be more creative, to get that inclusionary. And there's ideas that we haven't thought of that they're emerging and evolving, and so this kind of language, the way it's currently embedded in the last 10 years of tentative map approvals, it didn't have that other category. It's here, so if they had thought of it at the time when they went through the public hearing process, they could have just added that, and you still might not have gotten the specifics of that proposal, but you would have gotten that they wanted to do something more creative that would be vetted by staff, that would be adopted by the housing authority. We didn't think of it until now as they're starting to emerge. And so from this day forward, our intent is to build that flexibility in up front. And we don't know exactly what they'll look like, so it is a little free form, but in terms of that technical balance, the way that subsection D states, innovation encouraged, innovative alternative to providing affordable housing not outlined in this chapter, evaluated by staff, and that's an interdepartmental approach, and considered on a case-by-case basis. Substitute programs shall be permitted providing that the objectives of the housing allocation plan are being met with the alternative proposal. So the criteria is everything set forth in that housing allocation plan in terms of affordability, how it's monitored, term of contract, distribution, design quality. Those things are all going to apply. Looked like you had a question.
Yeah, Commissioner Edmondson.
I have a question about that section, actually. So when I read it, excuse me, and it says that substitute programs shall be permitted providing at the recommendation of staff and determination of the review authority that the objectives of the housing allocation plan are being met. And then I see the proposed condition that says that for the purposes of this condition, the director of Planning and Economic Development is designated as the review authority. Mm-hmm. I'm not necessarily convinced that the way this code section is written contemplated the review authority being part of staff when it sort of divides the things that need to be done in order for the substitute program to be permitted. When it says at the recommendation of staff, that's the first thing. And then the second thing is the determination of the review authority. So if it's the same sort of body that's doing both things, it's like a separation of power that's going away. Mm-hmm. Would that be somewhat accurate?
Yeah, I mean, this is something that we've discussed, and the way that it's specifically worded, we felt that the existing language didn't give staff any additional authority, and that was debated at length between the applicants and staff. So that's why we're bringing this to you for your permission to allow staff to work with an applicant up front for innovative solutions.
Right. Just the idea that the Director of Planning and Economic Development could be designated as the review authority, is that consistent with other places where review authority is discussed in the city code?
Well, the director is a review authority.
Okay.
It's just that, so it can be debated, it was debated that the director is a review authority throughout the code, throughout the city code, not just the zoning code. And that it could be, as a review authority, it could be pursued that if that's the extent of decision-making at that point, and at this point, we're trying to implement, record the map and implement the housing allocation plan. But at a sort of in a abundance of caution, we're bringing this to the Planning Commission to be more explicit in the condition language that that we would have that authority to accept an alternative compliance program. And it wouldn't be any different than if they had come in. If we knew that they were going to invoke this clause, we really should have been more general when we were conditioning these projects, because it was always there. And even at that time, the Planning Commission wouldn't be acting on the specifics of that proposal, just that you were allowing X, Y, or Z, and Z being this alternative compliance path. So the permission that you're providing is just simply that the applicant can be more creative than than the sort of rote application of it, and work with staff and work with the Housing Authority to get into the specifics to meet the objectives. So we're just trying to be very clear, and that's why we read that, and we thought this really needs to come to the Planning Commission, and from this day forward, we want to put that option just out front.
Great, thank you.
Okay.
Okay. Commissioner Groninger, do you have another question?
Yes, a couple, and they're really aimed at least for myself, but clarifying. And when looking at this, two words stuck out to me. One is in perpetuity, I guess 3 words. The other is process. And I agree with Commissioner Stanley that it's always good to be able to take and give more decision-making in kind of a controlled sense back to staff on a number of things. And before I go further, I want you to really understand I have immense respect for the work that staff does here. In my time in Planning Commission, I've been really impressed. My concern here on process, I guess, is that once we agree to this, then it seems like the Planning Commission's role and connection to land uses in perpetuity is gone. You know, that's the way it appears to me. At the same time, I think the staff and the Planning Economic Development Director needs a lot of latitude to work with various applicants and various proposals, innovative proposals such as this. I would feel more comfortable, however, that when those agreements are reached, that at least the Planning Commission have the opportunity to, in essence, ratify them after the fact or whatever. One, to keep us informed how land use decisions are impacting, especially in this case, moderate housing allocations, costs, so on and so forth. But also, I think it's just a good source of information for us to see what the effect of things that we have agreed to as a Planning Commission, you know. That's probably my main question. Have a number of other questions, again, related to what ifs, basically. Irrespective of, and I would think that the Sonoma County Housing Land Trust would be someone we'd want to work with in perpetuity, I guess you'd say. But, you know, what happens? I'd like to get a better sense. What happens 10, 15 years down the road if the Housing Trust sees an opportunity, if they wanted to sell that property so they could reinvest it to get other property, which then would, in essence, expand and put in other areas the same sort of innovative idea in terms of helping reduce housing costs in the future. Other questions though they would go, I'm sure they're all legal, is how title documents look, both on the property and the structures. I think I would understand those, but also I think there would need to be, and I would assume there would be, a lot of clarity put forth to say if I were to buy the structure, I would be so informed that I'm buying a structure, not the property, but then are there any constraints on me to sell my property or my structure at a later date, so on and so forth. Those are probably way too technical for now, but they are questions that come into mind.
Maybe I can help a little bit because we're traveling over into the example of the contract that they've been trying to develop and the particulars of that. And again, we're just looking at broadening the language. We already do in lieu fees inclusionary. When we agree to inclusionary housing, we don't, as a planning commission, typically get all of the data and details and et cetera. Or maybe you can just tell me what happens if somebody does, we've approved it with the condition as it stood before. Somebody wants to come in and do inclusionary. What happens there? I think we need more education.
I'll respond if I may, and if I could take a step back, I would like to make kind of 3 points. One is that the HAP itself does include a definition of review authority that does include the director of the department. So we're not stepping outside of the bounds of the HAP itself, but we are clarifying that for these purposes, that is where the decision-making authority lies. I would also just like to clarify that all we're talking about is compliance with the housing allocation plan. So in terms of broader land use, all of that decision-making that would normally be with the Planning Commission still remains with the Planning Commission. As Chair Cisco said, exactly that. We're looking at just how does the applicant comply with the HAP, and in the past, it's been limited to confirming compliance with a payment of fees, confirming compliance with on-site and the number of on-site units and the constraints. And this just opens the third option that is already in the HAP of some different alternative compliance modes. In terms of how are those enforced, the Housing Authority is given responsibility under the HAP for entering into agreements to restrict the properties. Those agreements run with the property. The standard, we have a standard boilerplate that we use in these cases. Under the HAP, they run for 30 years. If there's a density bonus thrown in, it runs for 55 years. The primary difference for this proposal is that it would run in perpetuity. We would be working out the specific language of that agreement. The Housing Trust has already proposed a draft. We'll have some negotiations. We'll go back and forth. This is a type of agreement and type of process that the Housing Authority is quite used to dealing with. As I said, these agreements are recorded. There is an enforcement mechanism. Buyers are informed not only through the recordation of the agreement itself, but there are, when it's an ownership project, there are resale restrictions, which are also recorded on the property. We currently require a new resale restriction be executed and recorded each time the property changes hands. So we're talking about maybe doing an acknowledgement rather than a new, a full resale restriction agreement. But that's details that, gets really down into the weeds. So yes, these are agreements are recorded. They run with the property. If the property changes hands, the new owner is still bound by those agreements. There are enforcement mechanisms in place, and we do have a history of working with these. I don't know if that answers your question.
Commissioner Duggan?
So I'm assuming on going forward, if we get a new application for housing development, and you've worked out some kind of agreement like this before we see it, that we'll be able to weigh in, comment on it if we think it makes sense, or if we totally disagree with it, or so we'll be able to we'll be able to review it ourselves then. Is that correct?
That is not how the process currently runs. These agreements are generally recorded at the time of the recordation of the final map, or after, at the time, prior to issuance of building permits. So they usually come after the Planning Commission has already approved the fundamental entitlement. And I think that's the process we would prefer to keep, because there is a significant amount of work that goes into drafting and getting those agreements executed.
Okay, thank you.
Yeah, and again, just for clarification purposes, what we're doing in making this modification is simply including the innovation section, which we haven't included before. And the reason why you can't reach for it now with this particular applicant is because it hasn't been included in our standard condition of approval, even though it existed. And so we're now just including something that has already existed, but better defining who the actual review authority will be, which will be the director. Am I
correct.
on the right track there?
Yeah, that's
okay.
correct.
Okay, so that's really what we're doing, is we're taking a section that already exists, we're just adding it so that we're not just repeating the same two options,
Right.
which we've always used, and better designating who the review authority will be. And it isn't us.
Right. That clarity, that's what we're seeking.
Okay. Okay. So any more questions of staff? I'm going to give applicant a chance to give us some information here. Okay, applicant, you want to come down and, nope, nothing? Okay. They aren't going to. Any other questions? I know this is, okay, go ahead, Commissioner Groninger.
I don't know so much if it's a question or comment.
Okay.
Kind of wrapped together.
Well, we're going to get to that anyway, might as well.
I understand
Oh, wait,
that.
no, that's a public hearing. I got to
Pardon?
go ahead and ask your question, and then it is a public hearing. I have to open it.
Oh, okay. Yeah, I didn't.
Got so involved, I almost forgot.
And I understand what we're to do tonight.
Okay.
I'm looking to the future, I guess. In reading this doc, what we were given, which I thought was fine, good information, so on. And this appears to be a first-time test of going this way, which seems to be rather good. And it may be related to, if I heard Commissioner Duggan correctly on a question, is in the future, say this becomes the end-all for housing, whatever, that it would seem that a number of other developers would want to go this route, or at least take this option. And in the course of the development of their project, say before it comes to the Planning Commission, it would seem to me, if that would be their intent to involve, say, the Sonoma County Housing Land Trust, that sort of information, and if not the exact details, but that we could at least see what is being planned and discussed in terms of an agreement that then gets us to where I think we all want to be. So in other words, I guess my suggestion is I'd like to see those as part of future projects, because I would assume in the future they're going to, there'd be a good chance that a number of projects with this sort of use of this option, say, would start at the very beginning of the development of the project by the developer and so on, and then they start working with city staff, and then ultimately, come before the board or the planning commission. And so it'd be nice to have that information perhaps as we're dealing with whatever approval process on a particular project. That's what I'm.
Well, except that isn't really how the process has been going. I mean, they don't typically decide at the beginning and tell us necessarily. It's more typical that they decide, as this one did later, and started to develop. So I think one thing that might be helpful is it might be helpful for us to have maybe a study session or a staff presentation that really helps us understand how the inclusionary housing works, if that's inclusionary rental housing versus this is going to be for sale affordable housing, which we haven't really dealt with that. And I think that's why you're seeing the in perpetuity particular clause in this potential contract, again, that we're not voting on. I think it might be helpful if we could get a staff presentation, maybe through Lisa, more specific as to how those contracts are developed, if it's an inclusionary rental housing. As these maybe are developed and approved, give us an example of one. But I don't think we will be getting them as projects come forward, because I don't necessarily think those decisions will be in place as they seek those entitlements.
I see the possibility that they would.
Well, there's a possibility, but yeah, well,
once this
okay.
becomes known as an option and a tool, and it seems to me it would be a great one for all parties involved, that they would want to have that part involved right from the start of the process. That's all I'm saying.
Yeah. So you're saying if it was already proposed, the director had the opportunity and staff had the opportunity to approve it, we would be getting a sample of how that would be impacting the project when we're looking at our entitlements. That's what you'd be asking for.
Not exactly.
Okay,
All
I guess I'm
And again,
confused.
we're dealing in the future. And
Well, we're dealing in possibilities,
But-
and I don't want to get us to get too vague here, because again, we're really being very specific about what we're asked to do here. I think it's opened up our imaginations as to all the possibilities. Again, getting that example, it's opened up our imaginations, and I guess maybe as these things get developed and approved, it would be helpful for us to see how that process is going, to be educated in that way. But to be clear tonight, what we're looking at is modifying language, adding it to not just this approval, but future approvals, just so that option exists. And it may not look at all like what this contract looks like at the end. It may, it's about innovation, and so we can't be real specific. But the language is already existing. We're just putting it into our tentative map approvals, and we're designating the review authority as our director. So.
And I would add just one comment. So one thing that is for certainty is that a housing project or a development project must comply with the housing allocation plan. So the objectives will be adhered to in terms of the housing allocation plan. It's the how you go about that. So most applicants who even have a twinkle in their eye about doing inclusionary are going to be forthright that that's part of their intent, and they're going to see how they can provide inclusionary housing. They may not have all those details ironed out in terms of at the time of their tentative map, but the certainty is that they will implement it. If all else fails, even with the best intentions to do inclusionary, they can pay the housing in lieu impact fee. But in a spirit of encouraging inclusionary we're trying to open this up so that there's just more supportive tools to let them explore the how they might do inclusionary. And we have a lot of tentative maps that are in the works, new or previously approved, but nearing the edge of their time, that want to explore inclusionary housing. And the housing allocation plan encourages that, and it really opens up the how you get there. And so there's specific ones, and the idea of this is that we're actually encouraging however you can get there, meeting those objectives. And so that's the point of the item tonight, is that there's always certainty that the plan will be fulfilled, whether it's in lieu fees or inclusionary or some other creative option. So there's no risk of not implementing the housing allocation plan.
And if I could just add to address Commissioner Groniger's comments a little more, if a project does know at the beginning phases when they're coming in that they'd like to include an inclusionary element, be it the traditional on-site allocation or some innovative approach, and if they think that'll help move their project forward, then they would be forthright with it and present it, and that would be something that would come before the Planning Commission. But we, in the end, like to keep the flexibility in place with this condition, in that it allows, if for whatever reason that approach is not feasible, then there's always some option with complying with the housing allocation plan, even if it comes down to payment of fees. But there is a possibility that innovative approaches would come in front of the Planning Commission, not necessarily to be acted on, but it would be a component of the project that you'd be able to review and comment on.
Okay. Okay, so actually the applicant is the PED staff and not City Ventures, but I'm going to go ahead and open the public hearing tonight. I don't have any cards on this matter. If any members of the public would like to come down and speak to the commission, I'm not seeing anyone rise, so I'm going to go ahead and close the public hearing and bring it back to the commission. Any other questions before we move a resolution for discussion? Okay, would somebody like to move a resolution for discussion?
I'll make a resolution of the Planning Commission of the City of Santa Rosa approving modifications to Planning Commission Resolution number 11254 and Planning Commission Resolution number 11723 to provide the Director of Planning and Economic Development with authority to accept innovative housing allocation plan compliance strategies for the approved Fox Hollow subdivisions located at 2786 Dutton Meadow and 1615 Fulton Road, assesses parcels number 043-071-038 and 157020009, file numbers MJP05-001 and MJP14-008. Wait for the reading of the text.
Second.
Okay, so that was moved by Vice Chair Stanley, seconded by Commissioner Duggan. Vice Chair Stanley, you want to start our discussion?
So I love the idea of innovation. My questions are not designed in any way to limit staff's ability to come up with innovative strategies. That's, anybody who's listened to me sit here for 6 years knows that's what I'm all about. And I'm certainly not trying to put a mechanism in place by which somebody who doesn't have to come to the commission ends up having to come to the commission because they've come up with some substitute or alternate strategy, and so that now has to come to the commission. I think what I'm hearing, but I'll speak mainly for myself, is that we're turning over what we saw ourselves as a review authority. I read that line differently, but I understand what Ms. Hartman said about the review authority very often is the director. But also, we're a review authority, and very often in planning commissions, we have a staff recommendation, and then we are the review authority who analyzes, talks about it up here, and then we make a decision. So my questions were only in that if we are going to review and look at alternate strategies, is there some way for us to know now that we, in our mind, and I understand what Chair Cisco's saying too, the review authority is already sitting in this room. So My question is that we are a review authority as well. We are obligated as a planning commission to enforce the HAP and also the council goals and to keep those strategies in our mind. That's how we can be a better, more innovative planning commission as well. So I'm for this. I'm obviously going to vote for this to give the director, to change these resolutions in order to allow the director to act on that. I love the idea of the Housing Land Trust getting involved like this. It's everything we need in this community. So I will just say, Mr. Streeter, that if you have knowledge of alternate strategies before you come to the commission, because as we've heard, these agreements aren't signed, sealed, and delivered until the project is through final map. That's that point at which that happens. And I'm not asking you to bring it to us so we can say, that's not innovative. But if we start seeing strategies that we think aren't that way, I think that it's our responsibility as a planning commission to speak up to that. And I have the full confidence in this staff that you wouldn't allow that to happen. But I think as a planning commissioner, I feel that it's also my responsibility to be that backup, to be that second set of eyes. We're not staff. We are from the community. And so I think that it is incumbent upon us as commissioners to at least be aware of what's going on as these projects go through. So if you have that information, I think that it's important that it become part of the staff report. Other than that, I think it's a great idea, and I will be voting in favor of the language.
Okay. Commissioner Gronica?
Yeah, I really support this concept. I think it's really a great idea, a great approach. I think Peter probably articulated it better than I did in terms of really the role of the Planning Commission and also really a need to know as to how we are progressing with various strategies, and a good many of which come within our purview, if not indirectly, sometimes, and most frequently directly. And so I'll vote for this, but I have still some reservation about it. I really think there can be information item, whatever. I happen to like where I worked for a great number of years. I was in your folks' position, basically, and I often had to bring back, I wanted to bring back for ratification, the way they set it up, the board there, of agreements that we reached in the interest of that institution and here in the interest of the city as well as the project itself. That's all I'm really talking about. So.
Okay. Commissioner Edmondson?
I am a big fan of the specific idea that we see here with for sale, inclusionary housing, kept affordable in perpetuity. I think it's a really excellent affordable housing model that has worked successfully in a lot of different places. So I'm excited to see that come to a project in Santa Rosa. My only concern about it, I have no concern with approving the language for this particular project, and I'll vote in favor of it. My only concern was that generally we weren't starting with a determination of the review authority that would be inconsistent with the law. And based on the explanation of the definitions in the code that the city attorney mentioned, I'm convinced that it is consistent. To keep doing it in a case-by-case basis, where we say that for purposes of this condition, a certain person or body is the review authority, it leaves kind of an uncertainty before the first time it would come to the Planning Commission for entitlements about who the review authority might be for that specific issue. So I suppose we're considering this as a model for most, if not all, future projects and determining who the review authority is, and I think that's consistent with the city code also. It is a pretty large amount of discretion in the director, but I think the code contemplates it. And even though the Planning Commission exists to exercise discretion and to have political accountability for these kinds of decisions, if the City Council wants to write a code where that kind of discretion is vested in the director, then I think it's within its authority, and I'm not going to say that it's a bad idea, because we need innovation desperately, and we need to get units to buyers that exist, and so people can have roofs over their head. And anything that makes in-lieu fees a little bit of a less prevalent way of complying with the HAP is good in my book. So I'll be supporting this.
Okay. Commissioner Duggan.
I'm also in support. I think what you're asking us tonight is just making the existing language more explicit, and I think that that's a good thing. Let's see. Have some notes that I can't read here. I've got all sorts of confidence in the staff and director making good calls on this, and working with the housing authority and the land trust, like in this case. And I think it'd be really informative if going forward, if we see units built like this, that you give that to us as a report item, so we're conscious of what's going on out there. But I am in favor of the proposal.
Yeah, and I'm also in favor of the proposal. I do see it, I don't know, housekeeping is the correct term, because this is a little bit bigger than that, but it really is something that was contemplated in the one section, and now it's finally being utilized, which that's the exciting part, is that somebody is actually coming forward with some innovative ideas. And I appreciate Commissioner Edmondson's clarifying all of the legalities of that, because I think that's an important exercise for us to go through. But I think for our purposes of having those innovative ideas and contracts solidified in a way that makes sense, that review authority needs to be our director. So I'm completely in favor of it. I am in favor of us having the opportunity to get better educated about how those contracts go, or as they're done, to bring back and give us examples of that. Okay. So with that, that was moved by Vice Chair Stanley, seconded by Commissioner Duggan, and your votes, please. And that passes with 5 ayes, Commissioners Dipple and Crocker being absent. And that concludes that item. And do any of us need to take a break, or should we just keep going? Okay, great. So, next item is another public hearing, item number 9, public hearing on the Westboro subdivision tentative map time extension. It is an ex parte disclosure.
I visited the site and learned nothing that was not included in the staff report.
Okay.
I have nothing further to disclose.
Okay.
Nothing further to disclose.
And I have nothing further to disclose.
And I also have nothing to disclose. And looks like Mr. Rosa's staff tonight on this one.
Thank you, Chair Cisco, members of the commission. Yes, Susie Murray is the planner on this project, and she's under the weather tonight, so I'm going to pinch hit. So as we promised, you will be seeing this slide on all of your housing items. Although this is a time extension, it's not a new subdivision per se. It still is a housing project, and it will add 34 units to our 5,000 unit goal by 2022 of new housing. That represents a 1.3% percentage of that goal. I notice here it indicates Southwest Estates down on your slide, but this is the Westboro subdivision. So Westboro subdivision, it is in a previously approved project. The entitlements included a tentative map, a small lot conditional use permit, and design review for attached housing. It's a 34-unit residential subdivision. It includes a mix of housing types, including townhomes, duets, triplexes, and a single-family residence. As I mentioned, the current item before the commission tonight is a time extension. It's actually 2 time extensions. In total, with the second time extension, it'll take this project through and keep it valid until 2018. This is an aerial image of the site. You can see it's in northwest Santa Rosa. It's just north of Guerneville Road and east of Marlowe Road. Regarding the project history, the land use entitlements were granted in 2007. Those included the mitigated negative declaration, the tentative map, the small lot conditional use permit. In also 2007, mid-2007, the project went through design review and obtained final design review approval. Between 2009 and 2016, the state-mandated automatic time extensions applied, and that kept this map valid. And in 2015, the city received the first time extension request, the 1-year city time extension, and then the second one came in 2016. The reason for the delay and the reason why you have 2 before you tonight is subsequent to that first application in 2015, city staff took some time to analyze and understand exactly what conditions we can and cannot include on a time extension. So as we came up and finally reached our conclusions, we were near the next time extension application deadline. So we received that application. We'll process both of those, request the commission take action on both of those independently, and as I mentioned, that would extend the project through for another year from today. So this is the general plan. It's actually a split general plan designation. One of the portions of the site is medium low density residential. The other is medium density residential. I wouldn't say it's necessarily common, but it is acceptable to have a development that has 2 land use designations on the site. And this slide shows the zoning, and the zoning corresponds to those 2 land use designations, so R16 and R318. Previously, the approved project was reviewed pursuant to CEQA. There was a mitigated negative declaration prepared and adopted. Pursuant to CEQA Guideline 15162, given that there are no plan changes, no new information, or substantial changes to the project, that mitigated negative declaration still applies. This is the actual development plan, and you can see, as I mentioned, it's a mix of unit types, 1 single-family residence, and then a mix of duplexes, triplexes, and townhomes. And the colors indicate how those are dispersed. Staff did receive a public comment. It was related to tree preservation. And the tree in question is down in that corner of the site. The specific issue was that the person was concerned that the condition of approval that was associated with the original resolution didn't specify that the project was to comply with the measures outlined in the arborist report. So the commission is familiar. The typical approach is to say project shall comply with the measures indicated in the report prepared by, dated X. It was a little more broadly written. So if the commission wishes, that can be a clarification added as a condition of approval. So with that, staff is recommending that the Planning Commission approve 2 12-month time extensions for the Westboro tentative map subdivision. And I should note that the item just before this, that condition of approval, as we've indicated, will be something that we'll be taking forward on future subdivisions. We didn't realize that until after the writing of this staff report and the preparation of the draft resolution, so we don't have that language. I'd be happy to recite the specific language into the record if the commission wishes to include that. That language was given to the applicant. The applicant is here tonight and is prepared to make some statements. I would recommend that the commission request that the applicant affirm positively here tonight into the record if they are okay with that condition language. So with that, I'd be happy to answer any questions.
Any questions of staff on this? Okay, great. Thank you, Mr. Rose. And is the applicant here wanting to make a presentation?
Hi, my name is Kurt Kissling, and talked with Susie about both the tree and the measure that was before this, and we're fine with both.
So you're affirming positively that
Yes,
we
I
can
am
include
affirming
that in our...
positively, yeah.
Great.
Yeah.
Thank you. Thank you. Okay. This is a public hearing on this item. I'll go ahead and open the public hearing. And if anyone cares to speak on this, I do have one card, and that is Lloyd Iverson. If you want to come down and speak to us on this.
These cell phones ever do what you want them to. Okay, I'm Lloyd Iverson, 4230 Hargrave, Santa Rosa, California. I'm a member of the California Groundwater Association. I'm also on the Basin Advisory Panel for Sonoma County. I'm also on the Technical Advisory Committee for Water Planning for Sonoma County. I'm also a member of ASHRA, American Society of Heating and Refrigeration Engineers, and RSCS and WEF, Water Education Foundation. I'm also a Quaker, and I'm also on the site committee for Quaker Meeting, which is right next to this project that has the concern about the oak tree. And I wanted to thank the people for taking that oak tree into consideration. But I'm here tonight to give my opinion, and I can't speak for the meeting as a whole because Quakers do things very slowly. They do everything by consensus. It takes them years to come up with something. But basically, the way we see it is that we don't mind the development, but we would like it to be water neutral, because we see that Sonoma County is in an overdraft situation, which I'm very well aware of, over 3,300 acre feet a year in overdraft for over 30 years. We have land subsidence. We have confirmation of that from satellite, a number of studies. We also know that, according to tree ring studies, that a 75-year drought is not uncommon in this area. 25-year drought quite often throughout history. And that in the current state, to keep expanding the population when we're so oversubscribed for the water resource is, we don't feel it's responsible, because we'll all wind up on water rationing, and we don't want to be on water rationing. I believe Jerry Brown's office just came out with a very interesting bunch of legislation having to do with this. They're going to hold all the city's feet to the fire finally and say, look, you guys keep growing beyond your means. It's not going to keep flying this way. So not to belabor it, but we don't want to kill the goose that lays the golden egg. We need developers, and we wouldn't have anything here if we didn't have developers. We wouldn't have this building, we wouldn't have this city, we wouldn't have anything. But what I'm saying is that the nest can only hold, say, for example, 12 eggs. Well, we've tried to cram 20 eggs in the nest, and we're making the eggs smaller and smaller. So at some point, we're going to have to figure out another idea. So water neutral would be very nice.
Okay, great. Thank you, Mr.
Thank you.
Iverson. Anyone else wishing to speak on this item? And I am not seeing any other members of the public here, so I'll go ahead and close that item. And Mr. Rose, would you like to address Mr. Iverson's concern?
So perhaps what I will do is I'll read the original tree condition, and then I'll suggest some recommended language just to add on to that.
Okay. And could you also mention water neutrality? Do we have some additions here? How is that handled with this?
So there were standard conditions of approval. Project was routed to all the relevant city departments. I can take a look and see if there are any specific conditions that would respond to that, but it was a typical subdivision reviewed by all the city departments.
Okay.
Regarding the trees, the original condition states specifications for tree preservation and protection during site construction activities shall be shown on the improvement plans and building plans. Tree dripline areas shall be accurately shown on site grading, drainage, and utility plans with the attendant protection instructions. So the suggested language would be, in addition to that, another sentence that simply states, the project shall comply with the arborist report prepared by Becky Duckles, dated October 26, 2006. And that report, in addition to an inventory and analysis of the existing trees, has a specific page, and it outlines 7 tree protection notes.
Okay. And then as far as including the language that we just worked on, can we make just a reference generally
You can make a
to
reference
that, or
generally.
should they read it into the record?
That's correct.
Generally?
And we've given that, the specific language to the applicant, and we'll include that as the condition of approval.
Okay, and then we have 2 resolutions for time extensions. We should mention that for both of those
Exactly.
extensions. Okay. Okay. Any questions of staff before we move on? Yeah, Commissioner Dunn.
It looks like the engineering exhibit has been revised since 2007, and it does look, it's got, like the stormwater conditions have been changed. It's got some additional language, so that's probably what Chair Sisko was
Right.
asking about before. And also, if I remember correctly, because I think this was one of my very first meetings when we had this project, I thought that there was real explicit language to save that big oak tree. So I'm glad that we're adding more into this.
Well, we have our minutes here. I'm not sure where our language was.
And just to follow up on Commissioner Duggan, the comment, certainly item number 3 of the revised Exhibit A, developers engineer shall comply with all requirements of the current MS4 or SUSUMP requirements.
Okay. And so could you just generally explain how that helps make water neutral so Mr. Iverson understands how his question relates to that condition?
I could, but I could torture it, so I'm going to let our esteemed city engineer
Mr. Lackey will
that.
help us out here. But yeah, I just want to make sure that it's clear for his benefit.
Chairman Sisko, Planning Commissioners, Larry Lackey, Engineering Development Services. This project came in previously under the old city SUSUMP program. We have changed our permit requirements and have updated the conditions to reflect this new extension, these new extensions. The improvement plans for the subdivision have been reviewed and have previously been signed by the city engineer. They will be required to revise those subdivision plans with the grading permit, with the issuance of the grading permit, to reflect the final SUSUMP report. The other issue is water conservation. This project will be required to, with the individual building permits for the residences, come in with a WELO review, which is water, I can't remember what the acronym means, but it essentially reviews the irrigation water use and reflects, essentially controls what landscaping can be put in to minimize the irrigation, and also will review the sprinkler systems so that we have very tight control over the patterns. And that is essentially the water conservation elements that we currently employ in the city. So if you have any other questions, I'll be happy to respond.
Okay. Any other questions on that? Great. Thank you, Mr. Lackey. Okay. So any other questions? Would somebody like to move a resolution for the purposes of discussion on the first extension?
I'll make a resolution of the Planning Commission of the City of Santa Rosa granting a one-year extension of time for the Westboro subdivision located at 1715 and 1801 Ridley Avenue, file number EXT15-0010, with amended text as presented by staff, since I'm not going to go, unless you want me to go through each one of those.
I think you can generally mention that you're adding to the tree preservation clarification that it complies with Duckle's report
Becky
dated
Duckle's arborist report.
dated October 26, 2006, and then generally refer to the modified language regarding the inclusionary housing in lieu fees and our innovative option.
Right.
Okay.
So,
I think we got it. Okay.
I think that is now officially in the record.
Okay.
Positively affirmed by the applicant.
Yes, don't forget that part.
And I'll second.
Okay, so that was moved by Vice Chair Stanley, seconded by Commissioner Duggan. Any discussion anybody wants to make on this? Commissioner Duggan.
I'll just make the comment that in the minutes from the 2007 meeting, there was an explicit request about preserving the big oak tree on the property line.
Okay, good. Glad we covered that. Okay, so with that, let's do our votes, please. And that passes with 5 ayes, Commissioners Dibble and Crocker being absent. And we have one more extension resolution.
I'll make a resolution
Oh,
of the plan.
wait a second.
Oh.
Yeah, Mr. Rose. Nothing?
I'm just getting the PowerPoint.
Oh, okay. Okay.
I'll make a resolution of the Planning Commission of the City of Santa Rosa granting a one-year extension of time for the Westboro subdivision located at 1715 and 1801 Ridley Avenue, file number EXT16-0038, with the amended text related to the arborist report of Becky Duckles from October 26th, 2006, as well as the amended condition of approval for innovative strategies for inclusionary housing.
And I'll second.
Okay, so that's moved by Vice Chair Stanley, seconded by Commissioner Duggan. Any other discussion? Not seeing any. Your votes, please. That passes with 5 ayes, Commissioners Dipple and Crocker being absent. That concludes that item. Thank you. And with that, we'll move to our final item, and Commissioner Edmondson is abstaining and needs to exit. Okay, so we'll go ahead and move to item number 10, which is also a public hearing for the Meadowwood Ranch subdivision tentative map extension. And it is an ex parte disclosure.
I have nothing to disclose.
I have nothing to disclose.
I have nothing to disclose.
And I also have nothing to disclose. And again, Mr. Rose's staff. We're working you tonight.
I've got a lot to disclose.
Okay.
I'm just actually going to introduce the item, the Meadowwood Ranch subdivision, and just speak quickly to this slide. Claire and I flipped a coin, and I lost this one. So
Oh, okay.
I'm going to do the handoff to Amy here momentarily.
Okay.
But as you can see, project represents 78 total units, 3.1% of the total goal for the market rate category. And I just did a quick tally, and the actions of the commission tonight in total represent 11.3% of satisfying the different categories that you see here. So we are slowly but surely getting on our way to meeting our housing goals. So with that, I'm going to turn this over to Amy.
Okay.
Good evening, Chair Cisco, members of the commission. As Mr. Rose mentioned, the item before you is a one-year time extension request for the approved Meadowwood Ranch subdivision. The original entitlements included a tentative map and also a small lot conditional use permit to allow for lot sizes less than 6,000 square feet and less restrictive setbacks. The site is 11.34 acres and is comprised of 2 parcels, and the tentative map subdivided the site into 78 single-family lots. This photograph here is a street view of the architecture. The site is located at 2853 and 2875 Dutton Meadow in southwest Santa Rosa, north of Bellevue Avenue. This is an aerial photograph of the site, and much of the area has been developed with residential uses. LCL and High School is in the bottom left corner, and there are some existing valid entitlements for additional housing on the properties to the south and west of the site. The site itself is flat and does contain a cluster of trees in the southeast corner. All those trees were approved for removal upon the tentative map entitlement that was granted. The map and conditional use permit were approved by the Planning Commission in August of 2007, and at that time the Planning Commission also recommended approval of the rezoning from planned community to R16 and recommended adoption of the mitigated negative declaration to the City Council. In October of 2007, the City Council adopted the mitigated negative declaration and approved the rezoning. As we've discussed several times tonight, the California State Legislature did pass a series of bills to allow for the automatic extensions of tentative maps and associated entitlements, and those bills kept this project valid through August of 2016. In June of 2016, the applications for the time extension for both the map and use permit were submitted to the Department of Planning and Economic Development. This is a general plan land use diagram which shows that the site is designated as low-density residential, which allows between 2 and 8 units per acre, and there is a small area in the southwest corner that's designated as low-density residential and open space. The difference between the open space and addition there is that you can only develop to 80% of the density, and that's to accommodate for wetland constraints. This project is consistent with both of those land use designations and also implements the city's housing policies related to meeting the needs of all Santa Rosa residents, and also pursuing those goals through allowing for increased densities, which is allowed through the small lot use permit. The site is zoned R16, which is intended for detached single-family residences, and the approved project is consistent with the applicable development standards for both that zoning district and also the standards for small lot subdivisions. This graphic is the development plan for the approved map, and the minor streets, avenues, and neighborhood streets are shown in gray. The green streets are actually public alleys, and each of these projects accesses the garage by way of the alley, and so the main streets have the front porch and front house and the garages to the rear of the property, which is consistent with many of the city's design guidelines. And this blue shape in the southwest corner is a stormwater detention pond. This was approved as a part of the SUSUMP requirements, and the applicants made it into kind of like a feature. Includes landscaping and a public pathway. The project did have a mitigated negative declaration prepared and circulated for the required 30-day period. the City Council ultimately adopted the mitigated negative declaration in 2007. The mitigation measures were related to both biological and cultural resources, geology and soils, in addition to hydrology and water quality. Pursuant to CEQA Guidelines 15162, based on the fact that the project has not changed and there's been no new information of substantial importance discovered, no additional environmental review is required for this proposal. Staff had no identified issues with the proposal. It was referred to all requisite city staff. Some of the conditions were updated in the engineering exhibit related to updated SUSUMP requirements and our water efficient landscape ordinance. At the time of writing the staff report, no public comments had been received. Today, I received a phone call just with general questions as to if the project had changed in any capacity, and I explained that it was just an extension and no changes were proposed. With that, the Planning and Economic Development Department recommends that the Planning Commission approve the one-year time extension request for the Meadowood Ranch subdivision. And I'm happy to answer any questions. The applicant unfortunately had to leave, so hopefully I can answer any questions that may come up.
Ms. Nicholson, were you able to talk with this particular applicant about adding the language that?
Yes, I was, and we corresponded by way of email, and she agreed to adding that language to the condition if the commission chooses.
We have in writing her positive affirmation.
Yes,
okay, great.
Yeah.
Thank you.
Sure.
Any questions of staff right now? Okay, great. This is a public hearing, which I'm going to open and close very quickly because there's no one here. And so, not seeing anyone, I'll go ahead and close the public hearing, bring it back to the commission. Any other questions before somebody moves a resolution?
I'll make a resolution of the Planning Commission of the City of Santa Rosa granting a one-year extension of time for the Meadowood Ranch subdivision located at 2853 and 2875 Dutton Meadow, assessors parcel number 043-111-005 and 043-111-006, file number EXT16-0023, with the amended conditions of approval for allowing innovative strategies for affordable housing.
Good job.
And I'll second.
Okay, moved by Vice Chair Stanley, seconded by Commissioner Duggan. Any discussion on this one? Great, pretty straightforward. Great, so your votes, please. And that passes with 4 ayes, Commissioners Dipple and Crocker being absent and Commissioner Edmondson needing to abstain. That concludes this item and concludes tonight's meeting. We'll adjourn to our January 22nd meeting. Right, thank you.